Thanks, Crystal. So good evening, everyone, and welcome to the 5th event in the Brennan Justice Talk series for 2021. And tonight we're focusing on the issue of Indigenous justice and treaties. My name's Dr. Elise Methven. I am one of the co-directors of the Brennan Justice and Leadership Program. I'm joined here by a few members of our Brennan team, one of my fellow co-directors from the UTS LSS, Mac Middleton, Crystal McLaughlin, our Brennan administrator, and most importantly, our special guest and presenter for the evening, Australia's first Indigenous Senior Counsel, Tony McAvoy. I would also like to acknowledge the attendance of other members of our faculty and the university tonight, including our Dean, Professor Leslie Hitchens. Now I'd like to hand over to First Nations student Olivia Henderson to do the acknowledgement of country.
Thank you, Elise. On behalf of the Brennan team, I'd like to acknowledge the Gadigal people of the Eora Nation, upon whose lands our city campus at UTS stands, and also from where I am broadcasting today. I would like to pay my respects to elders both past and present, acknowledging them as the traditional custodians of the knowledge of this land. I would further like to acknowledge the traditional custodians of the various lands on which all of you are attending and joining us today, and pay my respects to their elders as well. Thank you, Elise.
Thanks so much, Olivia, for that acknowledgement of country. Now, tonight we have the unique pleasure of being connected with UTS law students across multiple years, all clearly passionate about the issue of social justice. And before we begin formally, I'd like to lay out some just light Zoom housekeeping rules. So this Zoom event is being recorded for teaching, learning and event purposes. Only key speakers and those that ask questions in discussion time will come up in the Zoom recording. You each have the ability to hide and show your camera, as well as mute and unmute your microphones. When you are not speaking, please put your microphone on mute. If you find the event is freezing on your Zoom, click hide camera and that should free up some bandwidth. Now tonight we expect quite a large number of students in the Brennan community to tune in. So please ensure that you do turn your camera on when asking a question during the discussion time. We'd love to see your face. Lastly, and a very important request for our current students, in order to claim your 5 ROJ points, if I could please ask you to all list your full name now in the chat box as it appears on the UTS systems. Our Brennan team here will award you your points after this event. You can also use the chat box after this for any other questions during the event. And Mac and Crystal will respond while Tony McAvoy presents. So now that we've got our housekeeping settled, I'd like to introduce you to our very special guest and key speaker, Tony McAvoy SC, who will be speaking on the issue of Indigenous justice and treaties. Tony McAvoy is Australia's first Indigenous Senior Counsel. He is a Wirdi man who is a barrister at Frederick Jordan Chambers, co-chair of the Indigenous Legal Issues Committee of the Law Council of Australia, and assisted the Royal Commission into Youth Detention in the Northern Territory during 2016 to 17. Notably, between 2011 and 2013, Tony was an acting part-time commissioner of the New South Wales Land and Environment Court. Tony has recently been appointed as a commissioner on the New South Wales Independent Planning Commission. So I'll now hand over to Tony. Thanks, Tony.
Thank you, Elise, and thank you, Olivia. Thank you to the Brennan Project for inviting me to speak. I'm quite humbled and flattered to have been given the opportunity to speak this evening. I try and always take up the opportunity to speak to students if I can. I see students as being the key to a better future for us all. The bio that you've just heard, I think is probably a bit overly long, and I apologise for that. But I suppose that's what happens when you find yourself in the position to do things which are important, and then you have the drive and the obligation to follow through on those opportunities. And fortunately for me, I've been in some places where opportunities presented themselves for me that I have been very interested in and felt very passionate about pursuing. And so I always find, as most people do, that makes the work a lot easier. Today's topic is Indigenous justice in the context of treaties. But I suppose in the front of my mind is the issue of Indigenous injustice as a concept. I think that the four main areas I tell you about that I generally focus on in my work and in my extracurricular sort of interests are Indigenous over incarceration, which is my primary interest. Treaties is another. Native title, both as a professional pursuit and intellectual pursuit, I suppose, and the associated issues of resource use and heritage protection and climate change. In June this year, in Adelaide, at I think probably the first live conference I'd been to in a year and a half, there was the Australian Institute of Aboriginal and Torres Strait Islander Studies Summit. And during the course of that week-long conference, one of the theme days was on treaties, and I was asked to give a keynote presentation at that particular summit. The theme of my presentation about treaty was that we, as First Nations people, need treaties for our protection from the political policy circus that swirls around us. I made the point at that conference that at present, our only real protection at a national level is the Racial Discrimination Act, which I'm assuming most of you are law students, is Commonwealth legislation. It's from the Whitlam era, 1975 piece of legislation. But we know that the Racial Discrimination Act can be suspended. We know that because we saw it happen when the Native Title Act was passed, and we saw it happen when the Northern Territory intervention legislation was passed, which was extremely discriminatory towards the Aboriginal people of the Northern Territory. And so on both of those occasions, the Federal Parliament suspended the operation of the Racial Discrimination Act. And they could do that because it wasn't, those protections aren't enshrined in the Australian Constitution. We also know that because of Section 8 of the Racial Discrimination Act, governments can claim that their racially discriminatory legislation or acts are special measures for the benefit of First Nations people. That claim to an act or legislation being a special measure can be made by government regardless of whether First Nations people have requested that benefit or not, or consent to it. And so we saw in the case of Maloney, Queen versus Maloney, which was a case from Palm Island in North Queensland, where the Queensland government had enacted a series of amendments to the Liquor Act providing for alcohol management plans on Palm Island and many other Aboriginal communities in Queensland, prohibiting alcohol from being brought into those places. And the court found that the act of restricting the access to alcohol in those places, which were predominantly Aboriginal, was racially discriminatory, but nevertheless, it was a special measure for the benefit of Aboriginal people, because there were a whole range of behaviours that were said to be associated with the use of alcohol. But the High Court confirmed that this could be done without the consent of the people concerned. So we have no constitutional protection against legislation said to be for our benefit, or racially discriminatory legislation that would ordinarily offend the Racial Discrimination Act. And we have no protection of our position as First Nations or First Nations peoples. Obviously, we're not protected in any substantial way in the Constitution. Our rights are protected to some degree in the Native Title Act and in some Aboriginal land rights legislation, but those protections can be overridden. So I don't say that treaties are a panacea. I don't say that they can reduce the shocking rates of over-incarceration or reduce or cure our terrible rates of preventable disease. But they might give us some security and protection in the form of a positive protection against injustice. My observation from working with First Nations all over Australia, I've got clients from the Torres Straits through to Western Australia. My observations are that of those people who live on their own country and own their own lands, what they seek is greater control over their country and their lives. So this is particularly so for Aboriginal people in the Torres Straits, Torres Strait Islanders. For people who don't live on their own country. And so in many places around Australia, people were removed from their country at the turn of the 20th century and placed into reserves, including my grandparents, great-grandparents, and they were removed from country. That was a particular mechanism for dispossession which was used in Queensland. And in Queensland, we see that there are really substantial former missions where people were brought in from all over the region. In those places, people want to be able to return to their country to live. And so I have many clients in Queensland, and for many, that's their goal, to be able to create some existence on their own country, which they and their descendants can take the benefit of and live in some degree of security and safety with their families. So one of the observations I suppose I can make is that the real battle, from my perspective, is one for self-determination, self-governance. The central feature of the United Nations Declaration on the Rights of Indigenous Peoples is the right to self-determination. The United Nations Declaration provides for Indigenous peoples to have the right to free, prior and informed consent for acts by government which affect our rights. Of course, the United Nations Declaration and the rights of Indigenous people has been endorsed by Australia, but it hasn't been brought into domestic legislation. And in fact, it hasn't been brought into domestic legislation in Canada, New Zealand, Australia, or the US. The treaties, it seems to me, is a means for gaining access to those rights which are articulated in the international instruments such as the United Nations Declaration on the Rights of Indigenous People, but are not protected in the Constitution, and are able to be protected in a way that is greater than having rights protected by mere legislation. The difficulty we have in Australia is that there are no treaties here to guide us. Many of you will have read about the Batman Treaty in Victoria, which was ruled unlawful by the courts. Some of you will have heard of the Noongar agreements in Western Australia. So they were a series of Indigenous land use agreements which settled the single Noongar native title application over the bulk of southwestern Western Australia. Some people have described those Noongar agreements as a form of treaty for Australia, but in my view, they don't have the essential ingredient of securing any transfer of power. Another form of agreement which was intended to be a treaty is the Wirdi Agreement, which was entered into by the Narungga people of the York Peninsula of South Australia. The South Australian government, before the last change of government, had announced a treaty policy and invited a number of nations to participate in treaty negotiations. One of those nations was the Narungga people. They engaged me to assist them in their negotiations and provide advice. And there was a race on. It happened very late in the term of Parliament, of the government for the Labor government. And there was a race on to see if anything could be fashioned prior to the election. And what became apparent to the Narungga negotiating team and me was that the negotiators who were attending these meetings on behalf of the South Australian government had not considered at all how there might be any transfer of power from the South Australian government to the Narungga people. They were interested in service type arrangements that were really about government agencies doing things better. And it seemed to me that although there was a great level of commitment to the notion of achieving a treaty by the Minister for Aboriginal Affairs in South Australia at the time, Kyle Ma, an Indigenous man, that commitment hadn't translated to knowledge and the commitment of the bureaucracy as to what was needed to make sure. So even though the minister and the government would have liked to have called the agreement with the Narungga people a treaty so they could say that they had entered the first treaty in Australia, the Narungga people refused to have the word treaty in the document and insisted on it being called a Wirdi Agreement. And that made sense because I think it's easy to understand how having entered an agreement that's called a treaty, the Noongar people were unlikely to be invited back to the negotiating table at any time in the near future to renegotiate. So the contents of the agreement were insufficient for them to consider naming the arrangement a treaty. So because we don't have treaties in Australia that we can look to, where we tend to look is to British Columbia for guidance because of their modern treaty process. That process has been going on for some 20 years. Interestingly, that process commenced when the First Nations in British Columbia, through a collective forum, entered into an overarching agreement with the British Columbian provincial government and the Canadian federal government to set out some principles and the framework for this process. The BC Treaty Commission was created, and there's approximately 60 First Nations out of the 140 who are presently involved in the treaty process there. The treaty outcomes for the few that have entered the treaties are ones which involve the creation of a form of self-government, which is akin to a fourth tier of government, in my view, and it takes from each of the existing levels of government that we are familiar with. So from local government, from state government, and from federal government. And they have roles in taxation. They have power in respect of environmental protection and planning control. They have roles in child protection, education, health, but they also deal with issues such as parking and purely local government issues. It seems to me that that level of self-management is what many First Nations in Australia aspire to, a degree of self-management which allows each nation to be able to make its own decisions and exist in an economically and politically largely independent fashion. But one of the difficulties that I foresee in following the British Columbian model is that each of the transfer, in respect of not all, but many of the areas in which jurisdiction has been transferred from or recognised by the British Columbian or the federal government in the First Nation, there is reserved to the provincial government or the federal government a role in terms of being the final arbiter. And so in respect of child protection, for instance, the First Nation can have its own child protection system, but it needs to be accredited by the state, the provincial government, in order to have that decision-making function. There can be other legal processes which are able to be undertaken in the First Nation courts, but many of them have appeal rights to the equivalent of our Supreme Court in New South Wales or into the federal jurisdiction. And so whilst the agreements that are available, they're available online, the ones that have been entered into, whilst they don't explicitly speak of a submission to the ultimate power of the provincial government or the federal government, in fact, the way in which they operate can be interpreted as some form of submission. So in Australia, one of the political mantras which exists is that sovereignty has never been ceded. And I envisage that it will be very difficult for many First Nations in Australia to enter into an arrangement which can be interpreted as agreeing to a form of domestic dependent sovereignty in which ultimate sovereignty is ceded. There are some ways around that, and many people have spoken about it here in Australia, but it seems to me that one of the options for dealing with that particular problem is to provide for a contested sovereignty, whereby the agreements record the assertion by the First Nation of an ongoing and undisplaced sovereignty, and record the assertion by the state and the Commonwealth of a lawful and continuing sovereignty, and note that the parties acknowledge the contest. Now, I accept that that's a long way from where we are at the moment, where the federal government won't even discuss treaties. The political position is one where the only jurisdictions in which treaty processes are underway are ones which are not conservatively held governments. And if there is to be a national treaty process in Australia, it seems at the moment that it won't happen unless there's a change of government away from the Liberal National Party. I have given you this evening an overview of a very detailed and technical subject, but I can share with you that advocating, as I do, with a lot of other people, day in, day out, week in, week out, against government policies that have the effect, and government legislation that has the effect of causing our children to be removed from our families at rates that haven't been seen since the stolen generation. Seeing our young people incarcerated at rates that are extraordinary. The whole of the youth prison population in the Northern Territory are Aboriginal people, Aboriginal kids. Having advocated about those matters for years. I started out in the Aboriginal Legal Service in the 1980s, and I remember the protests when John Pat died in Western Australia. We were street marching in Brisbane when I was a law student and working at the Aboriginal Legal Service, and that's the death which inspired the Royal Commission into Aboriginal deaths in custody. That was in 1987, 1988. I know that our lobbying in these subjects is we're only doing what we can at the fringes to reduce the worst of it. We can't get the protection we need from just simply participating in a system where we advocate against the worst aspects of it. We've got to try and aim for something bigger and larger and better with greater protections. So I'll leave it at that point. I thank you very much for allowing me and inviting me to speak. I'm happy to take every question that you'd like to throw at me. I encourage you to be vocal and take the opportunity to ask me questions. Thank you very much.
Thank you so much, Tony, for sharing your insights with us tonight. As Tony mentioned, we've got plenty of time now for questions. I'd invite you all to either pop your hand up and ask Tony a question live. Don't be shy. And of course, you can pop a question in the chat box as well. But yeah, the floor is yours if anyone would like to ask anything at all. All right, we've got a hand up. Thank you, Robin. Yeah, ask away.
Thank you. Hi, Tony. Lovely to see you, and thank you for joining us tonight. I was really interested in the framing that you gave, the possibility of a recognition of ongoing sovereignty and the recognition that of the position that sovereignty is never ceded. I wonder if you could talk a bit more about that, because I know it is a concern, and it will be a something that needs to be acknowledged and recognised and incorporated into our position.
Hi, Robin. Thank you very much. Yes, well, in the US, they've had a long history of dealing with domestic dependent sovereignty, and they've had the benefits of operating under federal legislation, and for many First Nations there, that's meant that they've been able to obtain economic independence through taking advantage of the federal laws for gaming and other reasons. They are exempt from paying federal taxes, and there's a whole range of benefits that people are aware of and have been dealing with for over 100 years in the US. In Canada, it's not quite as clear cut, but the British Columbian Treaty Commission has been working and publishing papers, and if you go to their site, their website, you can see papers that they've published on the impact of entering into agreements and how First Nations sovereignty can be expressed. In Australia, I think that the grasping of sovereignty that we have is almost, it's one of the very few things that we've been able to retain. We've had huge effect on our people through the outlawing of the use of our language, our ceremonies, our rituals. We've had our histories stolen from us. We've had children taken away, and for many people, the claim to sovereignty, even though we haven't been able to get the ownership of our land back for many of us, is a really important bedrock, I suppose. And because of that, I could foresee that it will be very difficult for people to let go of it. And there is the option to proceed on the basis that the sovereignty question isn't resolved by a treaty, and that the parties to the treaty agree that it's an issue, that the treaty doesn't resolve. And so, in my view, that's not the sort of argument that an individual First Nation should be having with a state or federal government. That argument needs to be had by a very well-resourced representative body that can speak on behalf of a large proportion of our First Nations and who can match it in terms of firepower with the state and federal government. You know, these things take time to develop, but I can't see. I have difficulty seeing the way any state or federal government. I can't see it happening that they would acknowledge that the sovereignty has continued in a way which was not displaced by the British sovereign. Justice Robert French, former Chief Justice of the High Court, delivered a paper in 2017, 2018, which suggested that there could be a continuing parallel Indigenous First Nations sovereignty, but that it would be confined to those matters which were left over after the state and the Commonwealth powers and interests had been accounted for. And so he thought that that might apply maybe to matters of spirituality and cultural heritage, perhaps. I thought that approach was a little too diminished in terms of its appreciation of the strength and breadth of Indigenous sovereignty. I think there has to accommodate something much more expansive than just the crumbs that are left over, and that we use the negotiation table as a mechanism for the practical transference of jurisdiction where we can. There is no guidebook for this, though, Robert. It's
yeah.
Like myself, I suppose, who think about these things regularly, trying to figure out ways to deal with our own unique situation here in Australia.
And we're glad that you do, Tony, because thank you for sharing that, particularly that point on sovereignty, because I think there'll have to be a way to really accommodate that, in my view. Anyway, I don't want to hog the time. Thanks heaps for that.
Thank you for your question, Robin, and thank you, Tony. I really appreciate it. We've got a few more questions coming in now, and a more personal one for you, Tony, from Erica. She said, as the first Indigenous Senior Counsel, you provide so much inspiration for a new generation of lawyers. What are your thoughts on quotas or other forms of affirmative action to secure increased Indigenous representation?
I think in some fields and vocations, quotas are appropriate. I mean, many government agencies have targets for Indigenous employment. There's a question, it's questionable as to how far you can go in terms of the professions. I don't think you can have a quota for judicial appointments, or maybe the appointment of doctors, but it's certainly, there are lots of arguments to be made for having a proactive diversity and inclusion campaign. And so in speaking particularly about the field of law, the legal profession, at the present time there is an inquiry going on into judicial bias in the federal court system. It's an inquiry being undertaken by the Australian Law Reform Commission. I happen to be on the advisory committee for that inquiry. that inquiry is looking at not only bias as it occurs in court, where a judge might be accused of apprehended bias because of some relationship with one of the parties or witness, but also in terms of bias within the system as a whole, and how notions of unconscious and implicit bias, which are known to exist in Australia, can affect the judicial reasoning process, and what can be done to ameliorate that problem. And so they look at training for judges to ensure that they understand what implicit bias is, and how they might stop themselves if they're likely to be engaging in that type of bias. But they also talk about diversity and inclusion. And I think that's a very important conversation that needs to happen in the legal profession. In the same sphere is the work that's been done by Marcel Burns, ICLAP area, Indigenous cultural knowledge and learning within the legal profession. I'm particularly taken by some work that's come out of New Zealand in relation to the indigenisation of the law degree at New Zealand universities. And what they talk about there is a bi-jural legal system. So their system in New Zealand, they're trying to promote the education in New Zealand law schools of the system as being a bi-jural system. And they're advocating that the profession and the judiciary should be trained to understand the bi-jural nature of their legal system. And if we take those principles and apply them to Australia, well, we would say that there is a multi-jural system in Australia. We would say that there is not only the imported and statutory law that's created by the parliaments of Australia, but there's also the law of the various First Nations that exist and continues to operate and be enforced and adhered to. And it's a really fundamental change in the legal systems of both countries, but it's a discussion that I think needs to be had. I strayed a little bit away from the question there, but I thought I'd throw that in anyway.
Yeah, no, I mean, it touches on another question that we had from Molly that was about, the legal system in New Zealand, but it was really interesting to hear your perspective on that. I think it links quite nicely to the second part of her question, which is, do you think there is a place for a general governing document such as the Treaty of Waitangi in our legal system? And she says, thank you so much for your insights.
I do think that there is a place for something of a national agreement. I have to say, and I've said it before, I'm very concerned about the development of different treaty processes in different states and territories, because the adequacy of the responses from the states, the various states and territories, will be reflected will reflect the various bargaining power of the First Nations in each of those places. And in some places it's stronger than others. And I know from having been involved in the negotiation of many Indigenous land use agreements that it's not, the quality of the agreement is not determined by the strength of your client's case, the extent of their connection, traditional they are, how strong they are in their culture, and how many people live on their country. It's none of those things. The strength and value of their Indigenous land use agreements always comes down to their bargaining power, their capacity at the bargaining table to exert power and influence over their opponents at the negotiation table, and that's the state. And so it seems to me that if we are going to ensure that everybody benefits in an equitable manner from these treaty processes, that it's critical that we have a national treaty framework that gives some guarantees of minimum outcomes and appropriate resources to ensure that everybody comes into it with at least some bargaining power. And so I'm worried about the position that we're in at the moment, where the federal government is refusing to engage on this issue.
Well, I think that's really interesting, the way that you talk about that. I mean, in terms of bargaining power, when looking at native title claims in Australia, if we compare New South Wales to the Northern Territory, do you think, I guess in the Northern Territory, claims seem to go through the court system a little bit quicker and a little bit more successful? What do you think are some of the reasons why native title claims in New South Wales have those extra few hurdles?
New South Wales, the way in which, sorry, I'll start again. The native title claims process in Australia is one which is particularly onerous on First Nations. When he was on the High Court bench, Chief Justice French, as he was then, wrote a paper about the burden on First Nations being so onerous that it was appropriate that we consider developing a presumption of connection, a rebuttable presumption that people had connection, and it was a matter for the state to disprove it because the burden was too high for First Nations. And there was an Australian Law Reform Commission inquiry into that, and the inquiry came back with a recommendation that perhaps we didn't need to develop a presumption, but rather rely upon the development of systems within the federal court to make appropriate inferences, which meant that those burdens weren't so onerous. Well, the problem is, of course, that the judiciary is made up of a host of individuals, and some judges are quite willing to make the inferences and others are reluctant. And in New South Wales, because you have to prove the continuity of your law and custom over from the time of sovereignty, and in New South Wales, sovereignty pretty much means sovereignty, 1788, we're talking about 10 generations of people.
Mm-hmm.
In the Northern Territory, a lot of the places, the British didn't arrive until the late 1800s. And so what you're talking about is people whose grandparents remember when the British arrived, and they only have to prove their continuity of connection and their continuity of their law and custom for 2 or 3 generations. So it's that much easier. But that doesn't mean to say that the claims in New South Wales could not be dealt with a lot quicker. And so what we have in New South Wales is a system where the government has failed over decades to adequately fund the department in government that deals with the Aboriginal land claims under the Aboriginal Land Rights Act and the native title claims. And so if you look at, there's a report that came out last year, prepared by Chris Ronalds under an independent inquiry, and she found that there were something like 39,000 Aboriginal land claims unresolved. There's a claim that's unresolved from Brewarrina, for the Brewarrina Common, that was made, I think, in 1985, that hasn't been resolved. And the same can be said for the native title system in New South Wales. And if you wanted to, you could look at the Western Bundjalung native title determination from 2018, I think. And there are comments there by Justice Jago of the Federal Court. I think at paragraph 40 or 41, I've quoted it a few times, where she says this is unacceptable, totally unacceptable that people should have to wait 15 years for a native title settlement, or whatever the number was in that case. She said it in many cases because that's how long it takes in New South Wales. Mm-hmm. And in my view, it's mostly because of the inadequate resourcing of the agencies to do it. And that is a denial of justice. It's an outright denial of justice, where the laws are created by Parliament for the distribution or redistribution of land or the recognition of rights, and yet through the executive government and the administrative government, they fail to adequately resource the government to do its job. Straight from the question.
No, yeah. So thank you, Tony. We have another live question actually from Olivia. So yeah, go ahead, Olivia.
Hi, Tony. Thanks for your talk. I was just wondering a little bit more about the Canadian agreements that you were talking about, and that kind of fourth level of government, and whether that has jurisdiction over a certain land area or over people, and whether you think a system like that could work in the Australian context.
Yes, I do think it could work in the Australian context. The question is a good one. So the environmental and planning laws tend to be confined to their Indian lands, as they call them, the lands that they've been able to acquire through agreement or their land claims processes or previous treaties. But they also have jurisdiction over their citizenry, and so it might be that they have jurisdiction over their citizenry within their territorial boundaries, even though that includes lands that they don't own. So it's not a straightforward territorial carve out, which makes it a bit more complex, but it's nothing. It's no more complex than the system that we have here, where you can park your car at in a ticketed parking area and get a ticket from a council officer. But if you reverse out of that car park and you crash into something, then you get a ticket from a state officer, from a police officer, and not the council officer. And there are many examples where we deal with overlapping jurisdictions in Australia. It wouldn't be anything that we haven't dealt with or couldn't deal with. Yeah, so, and I think that absolutely it could work, and I look forward to sitting with some of my people on my country, making decisions about what happens at home.
Thank you.
Thank you, Tony. We've got about 5 minutes left, so maybe time for one more quick question. But we've got one from Maya, and she has said, you made the point that Indigenous children are being taken away from their parents at record levels. not seen since the stolen generations. Is there anything we can do in the immediate future to tackle this issue whilst working towards a treaty and/or constitutional recognition?
Just to be clear, I do not say for a moment that we need to back off on all of the other advocacy that we are doing. We need to be going as hard as we can, trying to slow down and, if we can, stop the effects of really often quite brutal legislation and policy. With respect to the protection of children, I think it's difficult because the danger for children is really embedded in Australian policy and mindset in a way that is very deep-seated. So, you know, Aboriginal children are removed from their families largely for what's called neglect, or rather than physical abuse. And that comes down to public views about parenting. And so in the Northern Territory Royal Commission into the protection and detention of children, in which I was senior counsel assisting, we looked very closely at this in the Northern Territory. And it was very apparent to us that where you have families who are living in very overcrowded conditions because there's not housing, and who are chronically impoverished, a social worker is not going to understand the benefits for that child in remaining in their family, in their community, where they speak their language and they have a skin name, and they grow up in the company of their peers, and they go through law, as opposed to the horror of the social worker, that they've got a runny nose and that they're sleeping 5 till bed, and they've got dirty clothes, and the fridge doesn't have enough food. And these are the decisions that are being made all the time, and children are being removed because the system doesn't provide adequately for the value of our culture and our way of life. And I'm not sure how you change that. It's a very deep-seated thing that we are constantly dealing with. That I mean, this may be heretical, but I have been and continue to be troubled by the Close the Gap process. Simply the name of it, I find insulting. The insinuation is that everything will be good for us if we are more like the white fellas, and that's what the child removal process is about. It's a process of assimilation, and it's abhorrent, and it will be the subject of another Royal Commission in another 10 years' time. But I don't know the answer to that. That issue is one which really needs to be solved at a higher level of government, I think. So I mean, you can certainly contact your local members and the ministers and complain about it.
Yeah.
And let them know that you're a law student and you're worried about it and think that more can be done. But it's a big problem. It's one of the big issues, I think.
Hmm.
It's
That, yeah.
a consequence of colonialism.
Yeah, yeah. Oh, thank you so much for answering all of those questions, Tony. We really appreciate it. We're running a little bit over now, but on behalf of the UTS Faculty of Law, the Law Student Society, and all of the students here tonight, I would like to thank Tony McAvoy, Senior Counsel, for sharing your time and expertise with all of us here tonight. Your insights have shed further light on Indigenous justice issues and the importance of treaties. On a personal note, I hope that someday soon we do have the will as a country to implement a treaty. And as you put it, I hope that this will one day act as a positive measure to protect against injustice. Thank you so much, Tony. Thanks, Tony. As a reminder, tonight's event accrues 5 ROJ points, which will be awarded internally to each of you in your Career Hub Brennan workflow. I would like to extend an invitation for you all to join our next Justice Talk on the 9th of September with special guest and UTS Law alumna, Kate Eastman, Senior Counsel. That concludes tonight's talk. Thank you so much, everyone.
Thanks, everyone. Thanks, Tony. I just wanted to second Mac's call for the treaty, and you've given us so much to think about. So we're all going away with so many takeaways from that. And hopefully we will try and aim for something bigger and better and understand that involves a transfer of power. So stay safe, everyone. And yeah, we look forward to seeing you at the next event. Thanks, Tony. Thanks, everyone.
Thank you, Tony. Thank you, everyone.